Okay, Assalamualaikum dan selamat sejahtera. Kami dari kumpulan 10 dari seksyen 11 akan membincangkan borang kontrak PWD daripada clause 70 hingga 81. Okay, untuk scope of work, saya Ashrafi Ali akan buat clause 70 hingga clause 72 dan Hafizi Irfan akan buat clause 73 hingga clause 75 scope of work and front page. Syazul Rahman akan buat clause 76 hingga clause 78 dan Khairi Aziman akan buat clause 79 hingga clause 81 and compiling. Okay. Untuk clause 70 amendment PWD, clause 70 amendment mention no modification, amendment or waiver of any of the provision of this contract shall be effective unless by mutual consent and made in writing by way of supplementary agreement, specifically referring to this contract and duly signed by the parties. The provision in respect of such amendment, variation or modification thereof shall be supplemented to and be read as integral part of this contract, which shall remain in full force and effect as between both parties. So, untuk relate dengan clause 70 applicable PWD di PAM 2018 adalah clause 11.1 iaitu variation, provision and prime cost sum. So, dalam clause ini dia mention about the term variation means the alteration or modification of the design, quality or quantity of the work, including the addition, the alteration of the kind standard, the removal from the site, any charge, any limitation of working hour, working space, asset to alteration, the execution or completion, the execution of temporary work. So, untuk CIDB 2000, clause yang berkaitan adalah clause 56 iaitu modification or revision to work program and or method statement. So, dalam clause ni dia mention the contractor shall from time to time during the progress of the work make modification or revision to the work program or method statement to take into account any change, circumstance or event affecting the progress and or the execution of the work. So, untuk comparison dia antara tiga clause PWD 203A form, no modification unless there is an agreement between the both party. So, manakala untuk PAM 2000 contract, modification can be made and borne by the contractor. And CIDB pula, modification can be made and the method statement shall be subject to approval by the superintendent official. So, untuk relatekan dengan case, kita akan tengok case MT Orchard versus E.ON. E.ON and MT had entered into a contract whereby MT would install foundation for a wind farm off the Scottish coast. The bespoke contract they had entered into allow the party of vary the work. So, the case show how important it is to be very clear from the outset how variation to the work will be valued under a contract and also to consider the possible variation that might arise. It is also important for developer to consider the variation and the possible financial outcome carefully before instruction a variation. So, seterusnya clause 71 confidentiality dalam PWD form 203 revision 1 2010 dia mention tentang 71.1 iaitu this contract and all such drawing, record, data book, report and all matter pertaining hereto shall be considered as confidential matters and shall not be disclosed to any third party without prior writing make sure agreement safe and aware. So, untuk relate dengan PAM 2018, clause 3.9 limitation of use of document. None of the contract document in clause 3.1 shall be used by the contractor for any purpose other than the contract Asset of the purpose of the contract, the party shall not disclose any of the rate and price in the contract bill to any other parties. So, untuk relate dengan CIDB 2000, clause 4.9 confidentiality and limitation of use of the document. The contractor shall treat the contract and everything contained in the contract a private and confidential. So, comparison dia adalah sama saja semua borang kontrak. In PWD 203 PEN 2018 and CIDB, all matters pertaining here to shall be considered as confidential matter and shall not be disclosed to any third party. So untuk relate dengan case adalah case Force India Formula 1 Team Ltd versus Aerolab SRL. Confirm the court shall be very slow to intervene in respect of the confidentiality clause which has been drafted carefully to balance the parties' right and obligation. Also, where confidential information become bound up in an individual employer own skill, experience and knowledge, in distinction can still be made between information and personal experience, and where the information can be traced to a particular source and can be potential amount to confidential information capable of protection. Seterusnya adalah clause 72 iaitu stamp duty. Untuk stamp duty PWD form 203A clause 72, they mention the contractor shall solely bear the stamp duty, legal cost and fee in the preparation and execution of the contract and anything accidental thereto. So untuk relate dengan PEN 2018 iaitu clause 44 iaitu fee and charge. The contractor shall pay an addendum fee the employer against any liability in respect of any fee, levy and charge, including any penalty which may arise from the contractor non-compliance with any law, regulation, bylaw, terms and conditions of any appropriate authority and service provider in respect of the execution of the work and all temporary work. If the contractor fail to pay, the employer may pass the said amount together with any additional cost in the connection shall be set off by the employer under clause 30.4. So untuk CIDB 2000 dia relate dengan clause 50.1 iaitu payment of custom duty and tax. The contractor shall be required to pay all custom duty and sales tax in respect. So untuk comparison dia, tiga-tiga borang kontrak ni gunakan membawa maksud yang sama iaitu kontraktor kena bayar semua any fee, levies and charge. Untuk related case, kita ambil case Strait and Anno versus Ciba-Brace Ltd. The contractor is required to build one straight footing based on the contract drawing. However, based on the condition of the construction site, the depth of the foundation is not enough. The court decided the contractor will also liable under law. Then the contractor is skilled that only based on the contract drawing in need sufficient where is also responsible with the designer. Seterusnya.
Saya Fizi, so saya akan terangkan tentang clause 73 sampai clause 75. Okey, so untuk clause 73 menceritakan tentang severability, iaitu jika mana-mana protokol kontrak yang menyalahi undang-undang ataupun peraturan yang berkuat kuasa dan terpakai semasa tempoh kontrak ini, peruntukan itu mestilah dipisahkan sepenuhnya dan kontrak ini hendaklah ditafsirkan seolah-olah peruntukan yang menyalahi undang-undang itu tidak pernah merangkumi sebahagian daripada kontrak dan peruntukan yang selebihnya hendaklah kekal berkuat kuasa dan berkesan sepenuhnya dan tidak akan terjejas oleh peruntukan yang menyalahi undang-undang atau tidak sah dengan pemecatan daripada kontrak ini. Okey, so untuk kontrak PEM, dia di bawah clause 2.0 iaitu Architect Instruction AI. Clause 2.3 subclause Provision Empowering Instruction. Upon receipt of a writing instruction from the architect, the contractor may request the architect to specify in writing which provision of this condition empower the issuance of the said instruction, and the architect shall forthwith comply with such a request if the contractor thereafter complies with the said instruction without invoking any dispute resolution procedure under the contract to establish the architect's power in the regard the instruction shall be deemed to have been duly given under the specified provision. Okey, untuk bawah SIDB pula, dia dekat bawah Superintending Office Instruction, di bawah sub clause Provision Empowering Instruction 3.2A dengan 3.2B. Okey, so untuk comparison antara tiga clause ni, kita boleh tengok dekat PWD, nama clause dia ialah severalty, and untuk PAM dengan ZDB pula dia di bawah Architect Instruction dengan Superintending Office Instruction. Okey, so untuk untuk dia punya case pula, kita boleh tengok Lowy versus United Pacific Insurance Co. The California Supreme Court held where a contract with real estate developer required the contractor to perform two kinds of work: excavation and grading work on lots and street improvement work. The contract was divisible, and the fact that the contractor did not perform street improvement work did not prevent his recovery for work done on grading and grade excavation. Okay, so clause 74 waiver untuk PWD form, dia menceritakan tentang failure by any party to enforce at any time, and provision of this contract shall not be construed as a waiver of its right to enforce the breach of such a provision or any other provision in this contract, or as a waiver of any continuing, succeeding and subsequent breach of any provision or other provision of this contract. Untuk PAM pula, dia di bawah clause 1.0 contractor obligation. The contractor shall use the contract document and any other subsequent document issued by the architect to plan the work prior to execution. If during the said planning and subsequent execution of the works, the contractor find any discrepancy in or divergence between any of the contract document and any other subsequent document issued by the architect, he shall give to the architect a written notice in sufficient time before the commencement of construction of the effected works, specifying the discrepancy of or divergence to enable the architect to issue writing instruction within a period which would not materially delay the progress of the effected works. Having regard to the completion date, such discrepancy or divergence shall not retake the contract. Okay, untuk SIDB pula, dia bawa clause miscellaneous provision 5.1 business ethic and 51.2 declaration against waiver. Okay, so untuk comparison antara tiga clause ni, untuk PWD, dia punya nama clause dia ialah waiver, and untuk SIDB is miscellaneous provision. And untuk PAM dia tak ada menceritakan tentang waiver ni. Okay, so untuk case, kita boleh tengok tentang Tiong Hung Ming versus Kalimantan Hardwood Sdn Bhd. Plaintiff bawah umum membawa saman kecederaan peribadi atas nama ibu bapa Okey, selepas kanak-kanak tu berumur 18 tahun, kanak-kanak itu menyelesaikan kes itu dengan harga $75,000 dan menandatangani pelepasan. Apabila dia menandatangani pelepasan itu, dia sudah dewasa, ibu bapa tidak menandatangani pelepasan itu. Sebahagian daripada tuntutan mahkamah, ibu bapa telah menegaskan tuntutan itu untuk perbelanjaan perubatan mereka yang mereka bayar bagi pihak bawah umur. Ibu bapa menegaskan semula tuntutan itu dalam mahkamah baharu. Mahkamah perbicaraan menolak saman kedua yang dibawa oleh ibu bapa dan alasan ibu bapa tersebut telah mengetepikan tuntutan mereka untuk mendapatkan semula perbelanjaan perubatan itu. Untuk next clause 75, loss applicable. Mostly ketiga-tiga kontrak ini dia menceritakan tentang kontrak ini shall be governed by and construction in accordance with the laws of Malaysia and the parties irrevocably submit to the exclusive jurisdiction of the Court of Malaysia. Okey, maksud dia kat sini kontrak ini mestilah dia di bawah undang-undang Mahkamah Malaysia. Okey, untuk kes kita boleh tengok Brathwaite versus Lamplight. Okey, Brathwaite telah berjanji untuk membayar Lamplight dan ini dianggap sebagai perjanjian antara mereka. Walaupun pertimbangan sudah berlalu, Brathwaite masih perlu membayar Lamplight €100 sebabnya ada permintaan, ada kefahaman tersirat bahawa pembayaran itu akan dibuat dan perjanjian itu mesti disahkan. Okay, di Malaysia, Seksyen 2A kelihatan cukup luas untuk merangkumi pertimbangan lepas dan syarat ia dilakukan atas kehendak pihak berjanji. Itu sahaja daripada saya.
Seterusnya, clause 76, social respond pada PWD Form 203A. This contract should be binding upon the respective social entitled of the parties. Untuk PAM 2018, clause 37.2, procedures for appointment of arbitrator. 37.2A, any party must serve written notice on the other party that such dispute or difference shall be referred to an arbitrator to be agreed between the parties. 37.2b, if after the expiration of 21 days from the date of the written notice to concur on the appointment of the arbitrator, there is a failure to agree on the appointment, the party initiating the arbitration shall apply to the President of Perhimpunan Arkitek Malaysia to appoint an arbitrator, and such arbitrators to appoint shall be deemed to be appointed with the agreement and consent of the parties to the contract. For CIDB, clause 51.3, notice of garnishment. The contractor shall not cause permit or suffer to be issued in satisfaction of any decree, judgment, or other order given or to be given against the contractor. Any notice of garnishment binding any property of the contractor which is in the possession of the employer. And for the corporation, in the PW mentioned about binding upon respective, in PAM mentioned about procedure to appoint assessors, and CIDB mentioned about order given to be given against contractor. For clause 77, untuk PWD form, epidemics and medical attendance. The contractor shall maintain the site in clean and sanitary condition and shall comply with all requirements of the government health and sanitary authorities. In the event of any outbreak of illness of an epidemic nature, the contractor shall comply with and carry out such regulation authorities for the purpose of dealing with and overcoming the same. 77.2, the contractor shall ensure that sufficient first aid are made available at suitable location on the site. For PAM contract 2018, clause 19.5, placing of insurance with licensed insurance companies. The insurance referred to in clause 19.1 until 19.4 shall be placed with licensed insurance companies approved by the employer, and the contractor shall deposit with the employer the policy and the receipt of premiums paid with copies extended to the architect and consultant. If the contractor makes default in ensuring of continuing to insure as aforesaid, the employer may insure against any risk in respect of which the default has occurred, and the amount of premiums and any other costs incurred or paid by the employer shall be set off by the employer under clause 30.4 for CIDB 2000, clause 40.4 safety measure. The contractor shall ensure that the construction plan together with all other tools and equipment, delivery works and other items used in the execution of the work are in safe, sound and good condition and capable of performing the function for which they are intended. For B, without limiting his ability under the contract, the contractor shall provide at his own expenses all workmen on site with the necessary safety equipment, including but not limited to safety boots, safety helmet and protective clothing. For the comparison, in PWD form, NCIB mentioned about first aid kit and health equipment government, but in APAM mentioned about insurance companies. For the cases, Lumbrams Mutual Casualty So versus Bovis Land Lease Limited. Between May 1996 and September 1997, Bovis was the main contractor on the project to build the Brad Retail and Leisure Centre in Glasgow. Dispute arose under the building contract, which resulted in Bovis insuring proceeding against the employer for over 37 million. The claim was made up of a number of elements, including a management fee and interest. In this case, however, the global settlement agreement did not even identify the insured loss in respect of any identifiable insured event. Mr. Justice Coleman had no doubt that in such circumstances, the agreement could not amount to a valid ascertainment of loss under the policy. Nor could he find any authority to suggest that if the settlement did not identify the cost to the insured of discharge the issued liability, the settlement could be opened up and the loss retrospectively ascertained by existing evidence. For the Clause 78, Technology Transfer. Clause 78. If contractor appoint foreigner professional, the contractor shall endeavour to ensure that the employer of the government are trained or exposed to the expertise of such foreigner professional pursuant to a program for technology transfer. For PAM 2018, Clause 37.5, consolidation of arbitration proceeding. Where any dispute arises between the employer and contractor, and dispute relative to the works of a limited subcontractor and arise out of or in connected with the same dispute between the contractor and such nominated subcontractor, the employer and the contractor shall use their best endeavour to point the sub-arbitrator to hear the dispute under Clause 31.3 of the PAM Subcontract 2018. For CIDB 2000, Clause 18.1, employer right to employ other contractors. The employer reserves the right to employ any person or contractor to carry out on the site work which do not form part of the contract, whether or not information in respect of such work and providing in the contract. Every person or contractor so employed shall be deemed to be a person and contractor for whom the employee is responsible for and not to be a subcontractor. Corporation for PW, PAM and CDB mentioned about employer, attorney expert. That's all for me. Next.
Okay, next I will explain about the clause 79 to 81. Okay, so the clause 78 is about general duties and performance standard. So in PWD, it is stated about clause 79.1, which is industry practice, which is the contractor shall provide and perform the work in a proper manner in accordance with good management and best industry practice. and to the best advantage of the government, and shall comply with all statute and guidelines direction issued by the government to the contractor from time to time. Clause 79.2 is competency. The contractor shall provide and perform its obligation under the contract and take all appropriate measures expected as a competent company, using due care and skill of a professional person providing similar service or work to ensure the works comply with the term and condition of contract. 79.3 Government interest. The government shall at all perform The contractor shall at all perform this work in such manner as will always safeguard and protect the government interest and take all necessary proper steps to prevent abuse according to provision on the contract. So in PAM, the clause that related to general duties performance is 6.1, which is material goods and workmanship to confront the description, testing and inspection. So all works, materials, good and workmanship shall be respective quality and standard described in contract document and required by the architect in accordance with the provision of the contract. So while in CIDB, it stated that in clause 17, which is commencement of work and possession of site. So in A, from a date of commencement of work until the date of practical completion, the latest date of practical completion, if more than one, certified by the superintendent officer pursuant to clause 20.2, the contractor shall take all responsible for the care, the whole or any section of the work as well as equipment, material goods indeed for connection with the works and all construction plan, temporary works and any other things and whatsoever. B. The contractor shall take full responsibility for the care and outstanding work which is undertaken or he obligate to complete during defect liability period until such outstanding work has been complete to the satisfaction of the SO. So here, what the comparison that we can do for the clause 79, which is in PWD, stated that contractor need to be competent and take care of the government interest. Meanwhile, in PAM, stated that the contractor must execute the work with the standard quality required by the architect. While in CIDB, it's more stated that the things that need to be take care good in the defect liability period. So the cases here that I can say that related to this clause is about Tengku Abdullah Ibn Sultan Abu Bakar and Ors versus Muhammad Latif bin Shah Muhammad and Ors and other appeals 1896 to AMR. So the case is about the flexible approach adopted by the court when according recognition to a particular relationship as being fiduciary in nature is, of course, one of the judicial impression dependent upon the fact pattern of the given case. Flexibility of approaches the hallmark of equity for when the principle governing equitable intervention will enter a domain comprising not rigid rules but broad and liberal doctrine that aim to achieve just a result according to the fact of a particular case. Equity has, in keeping with the purpose of origin, therefore refrain from laying down any strict rule for determining whether the particular relationship is fiduciary in nature or give rise to fiduciary obligation, leaving the development of its jurisprudence to a case-by-case basis. So the next clause that I will explain is about clause 80, which is restriction and procedure on use of important material and goods. So in PWD stated that 80.1, the contractor shall use a local good material as list as senarai bahan, barang buatan tempatan issued by IKRAM QA Services Sdn Berhad or issued by SIRIM QA Services Sdn Berhad, whichever is relevant. If contractor fails to comply with the requirement, the government may reject the goods or material which are found to be not in compliance with this requirement. 80.2, for local goods and material not listed as aforesaid, such goods material may be allowed if prior testing and certification for IKRAM or SIRIM, whichever is relevant, has been obtained. Where such testing cannot be carried out by IKRAM and SIRIM, the contractor may, with the SO prior approval, have testing to be done by another agency. Clause 80.3, under no circumstance shall be contractor be permitted in incorporate or supply imported material, plant, equipment, vehicle or other goods into the work to forming part of the scope of work except those approved by the government. The contractor shall at his own cost entirely substitute any material, plant, equipment, vehicle or any other goods proposed to be imported but not approved by the government with suitable local material, plant, equipment, vehicle and other goods, including making any necessary subsequential charge or adjustment to the design of the works. So in PAM, that related to this clause is in clause 14, which is materials and goods. Materials and goods delivered to the site in incorporation into a permanent work shall not be removed until completion of the work unless prior consent in writing from the architect has been obtained. In 4.2, where the value of such material and goods has, in accordance with clause 30.2, have been included in any interim payment under which the employer become a property of the employer. 4.3, the contractor shall be responsible for any loss and or damage to such material and goods, including material and goods supplied by nominated subcon and nominated supplier. 4.4, the contractor shall be deemed to have warrant that he has title free from encumbrance for such material and goods upon inclusion of the value of such material and goods in any application for payment under clause 30.1. In the event that the contractor is found to have made false warranty, any loss suffered by the employer shall be made good by the contractor or shall be set off under clause 30.4. So in CIDB, that related to the restriction and procedure use of imported material and goods, which is in clause 33, which is construction plan, temporary work, material and goods. 33.1, exclusive use of the work. All construction plan, temporary works, equipment, plant, materials provided by the contractor shall, when brought to the site, deemed to be exclusive intent for the execution of the work. B. The contractor shall not, without the written consent by the SO, remove such construction plan, temporary works, equipment, material and goods, or any part of the same aspect except for the purpose of moving it within the site, providing that consent by the SO shall not be required for vehicles engaged in transporting any staff, labour, construction plan, equipment, or goods to and from the site. So here what we can do and what we can understand the comparison between these three condition of contract, which is both PWD and PAM have mentioned that contractor needs to be responsible for any loss or damage of material goods on site. Meanwhile, in CIDB, it says that the contractor cannot claim from the employer if there is any loss happen. But in CIDB, it also stated that for any equipment or vehicle, there is no need to required to make a consent by the SO if the transport is using to transporting any stuff from time from site to site. So the cases that related for this clause is Wistech Engineering Sdn Bhd versus ESPLM Sdn Bhd, which is the applicant has been wound up in 2010 and the official receiver appointed as the liquidator filed an application for leave to appeal on 23 May 2013 without obtaining any sanction from the official receiver. After filling the application for leave, obtained the sanction form of receiver in 19 August 2003. The respondent in support of its application relied on sub 236 bracket 3 the Company Act 1965 to submit that its settled law that owns a limited company was wound up its assets and liabilities vest with the liquidator appointed. On the other hand, the applicant questioned whether such consent was necessary, referring to all the Bankruptcy Act 1967 and argued it was not a question of sanction but rather the prerogative of the liquidator to bring any action in the name of the company. The appellant also submitted that respondent has not been prejudiced in any way and no miscarriage of justice had occurred. So the last but not least is a clause time, which is it is about time. In PWD, it just stated very simple that time whenever mentioned shall be of the essence of the agreement. So yang in PAM 2018 it's stated in also material goods and workmanship to conform to the description, testing and inspection, which is for the subclass, which is no compensation for time and cost. So it's compliance by the contractor with a written instruction issued under clause 6.5 shall not entitle the contractor to an extension of time, no compensation for any loss or expenses that may be incurred. So in CIDB, time for completion, clause 20, which is the subclause 20.1, contractor to complete on time, subjected to clause 24, the contractor shall complete the works within the time to time for completion stated or in order of priority. So based on the three this condition contract, so the comparison that we can see here that the PWD and CIDB mentioned that the time is very important, which is a very important things that in document contract. Meanwhile, in PAM, no compensation for time if the contractor can execute the work. Meanwhile, in CIDB, it's been stated that the work needs to complete within the time to time that already stated in the contract document. So the cases that I can relate here is case Berjaya Times Square Sdn Bhd versus M Concept Sdn Bhd. So the case is about the appellant is a property developer. It set out to develop a project originally called Berjaya Star City, which is known as Berjaya Times Square. The project is massive venture. It has a completed. It comprised a various type of service outlet and office. Partial in a project were offered for the sale and the public at large. The respondent is a private limited company. It wanted to purchase a commercial shop lot in the project. It entered into an agreement with the appellant to purchase such lot. The agreement is dated in 24 August 1995. Several meetings were held between a party to determine when delivery could be made. The appellant told the respondent that what made deliver by the end 2001, but it did not happen. There was another yet exchange for correspondent. The respondent demand in to turn all sum in the hand of appellant and later claimed it was liable to pay the liquidated damage worked out according to agreed formula. The respondent then commenced proceeding claiming inter alia and declaration that the agreement had been rescinded for an order that the appellant refund the monies in the hand. There was also a claim for the damage. So that's all from us. Thank you.